Good evening and welcome everyone. This is Resky. I believe we're ready to go.
Now, it is now 7:02 p.m. First item of business is roll call. Mr. Booth?
Here.
Mr. Woolsey? Here. Mr. Piaquadio?
Here.
Mrs. Green?
Here.
Mr. Pillow? Here. Okay, will everyone rise for pledge allegiance to the flag for a moment of silence? I saw that our receiver taxes, Mary Lou Venuto, is in the back of the room. I am hoping she will lead us in the pledge, please.
I pledge
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Please be seated. Thank you all very much. Are there any changes to the agenda? Approval of the audit. Oh, well, first of all, comments on agenda items. Did everyone get an agenda? They're in the plastic holder to the right of the entrance. At this point in the meeting, if you want to comment on any item on the agenda other than the public hearing, you're welcome to do so now. If you wish to comment on the subject of the public hearing, you'll be afforded that opportunity in a few minutes. If you want to comment on anything else, you'll be afforded the opportunity to do that later this evening. But for now, does anybody wish to comment on items 9 through 12 on the agenda? Anybody? Okay. Since no one wishes to comment, we move to the approval of the audit.
Thank you, Mr. Resky. And with that, I look for a motion to approve this audit with a grand total of $1,036,779.36.
So moved.
Is there any discussion on the motion? Mr. Woolsey?
Yes.
Mr. Piaquadio?
Yes.
Mrs. Green?
Yes.
Mr. Bello?
Yes.
Mr. Booth?
Yes.
Item number 7, hiring of a sole assessor for the town of Newburgh.
Yes, at the end of October of 2011, Mike Fogarty, our assessor for 32 years, with a total amount of 37 years service to the town of Newburgh, retired. Since then, we've had several interviews and our search for a sole assessor. And tonight, I'm happy to say that I'm looking for a motion to approve John Venenzia as our sole assessor at a rate of $80,000 per year. Effective start date will be this Thursday, April 5th.
So moved.
Second.
And wait, isn't that for 2 years to?
This is for the completion of Mr. Fogarty's 6-year term. At that point, he can be reappointed for a full 6-year term.
Okay, is Mr. Venezia present this evening?
I didn't see him on the way in.
I didn't see him on the way in.
But he will be here Thursday.
Okay, the reason I'm asking is I am prepared to swear him in.
Okay. Keep an eye open.
Okay, is there any further discussion on the motion? Mr. Woolsey?
I have to abstain as I was not available for the interviews.
Okay, Mr. Piaquadio?
Yes.
Mrs. Green?
Yes.
Mr. Bello?
Yes.
Mr. Booth?
Yes.
Okay, we now move on to item number 8. This is the public hearing. You're welcome.
Yes, Mr. Zreski, have all the proper postings and advertising completed at this time.
Notice of this meeting has been posted in the lobby of Town Hall since March 15th. Notice of it appeared in the form of a legal ad in the Mid-Hudson Times on March 21st and in the Sentinel on March 23rd.
Thank you. And with that, I look for a motion to open this public hearing.
So moved.
Second.
Motion was made and seconded to open the public hearing. Mr. Woolsey?
Yes.
Mr. Piaquadio?
Yes.
Mrs. Green?
Yes.
Mr. Bello?
Yes.
Mr. Booth?
Yes. Tonight, we're here to conduct a public hearing on possibly imposing a 6-month moratorium on permits and approvals for adult-oriented business. This action would allow the town board to further study the negative secondary effects of adult entertainment businesses and would be the precursor to possibly amending the zoning code. This process was recommended in the Town of Newburgh's comprehensive plan. The study of negative secondary effects is a town-wide review and is not associated with any particular location, business, or geographical area within the town of Newburgh. The proposed moratorium will not have any effect in the operation of any existing businesses that engages in First Amendment activities. At this point, I'll now turn it over to Jeff Scully, who's a representative for attorneys for the town. He'll outline the proposed legislation, findings, and purpose. Mr. Scully.
Thank you, Supervisor. As Supervisor said, this is a bill that would impose and enact a 6-month moratorium on permits and approval for adult-oriented businesses. Now, the legislative findings section does discuss what has been termed negative secondary effects, which a number of municipalities, governmental organizations, and non-governmental organizations have found to be related to the operation of adult-oriented businesses. As the Supervisor also discussed, the possible amendment of the town zoning code along these lines to address negative secondary effects sometimes associated with adult businesses is set forth in the town's comprehensive plan. That is set forth again in the legislative findings supporting this proposed moratorium legislation. The purpose of this moratorium, as discussed in the legislative findings section, is to address negative secondary effects. And what negative secondary effects are traditionally thought of as being are certain crimes and generally undesirable conduct that is associated with certain First Amendment protected activities. When I say First Amendment protected activities, what I'm discussing is the rights of adults and businesses to sell, offer for sale, and to view sexually explicit adult-oriented imagery and words. These imagery and words are protected under the First Amendment. And as discussed in the legislative findings section, that protected First Amendment activity is not the target of the moratorium, nor any subsequent zoning amendment. Those activities will continue to be engaged in, as is the right of those business owners and individuals who choose to patronize those businesses. What this moratorium would do is for 6 months would prescribe the expansion of any currently existing adult-oriented business within the town, or the establishment of new adult-oriented businesses, except in designated locations. The moratorium designates those locations as being those areas of the town that are at least 1,000 feet away from the border of any residential zone, and that are at least 1,000 feet away from what are called sensitive sites, such as churches, mosques, synagogues, daycare centers, schools, parks, and the like. Again, the intention of the moratorium is not to engage in the regulation of protected First Amendment free speech activities. It is to allow this board a chance to review studies conducted, as I said earlier, by other municipalities, other governmental organizations, and other non-governmental organizations that have looked at the potential of negative secondary effects attributable to these adult-oriented businesses. The studies are rather comprehensive, they're long and they're extensive, and the moratorium would allow the board a chance to review those studies, while at the same time, if there's a finding that there are negative secondary effects, to limit the extent of those negative secondary effects by prohibiting expansion of current uses, as I said, or the establishment of new adult-oriented businesses, except in certain designated locations. The moratorium contains extensive definitions of what is an adult-oriented business, what is specified sexual activities, specified anatomical areas, how you define whether the business devotes a substantial portion of its premises to adult-oriented uses or specified sexual activities. These definitions are based on laws that have been enacted in other municipalities, which have been reviewed and upheld by various federal and state courts. They're designed to clearly put everyone on notice as to what type of activity is contained within the definition of an adult-oriented business, so everyone knows where they stand. So everyone is put on notice as to what is covered and what is not covered by the moratorium law. The moratorium would also, if enacted, would require that the town post notice both here in Town Hall, online, and on demand from anyone who wishes to know the effective dates of the moratorium. Again, to put possibly affected individuals and businesses on clear notice as to the time frame in which the moratorium would be in effect. Ultimately, the moratorium is a stopgap measure, if enacted, to allow the town board time, again, to consider whether to enact additional and permanent zoning changes to deal with the possible negative secondary effects. The moratorium law is not proposed to regulate First Amendment activity, and indeed allows First Amendment activity to continue as it has in the past, and to allow further expansion by new uses opening within the town, provided they open in accordance with the 1,000-foot requirement that I mentioned earlier. So with that as a preface, I turn it back to the supervisor.
Okay, thank you.
You're welcome.
Any questions or comments from town board members before you open the floor?
I have none.
If we're going to open it up to the floor for questions or for comments, if anyone who wishes to speak, please come to the microphone, state your name and address, and we'll open the floor.
And before we start, I'd like to point out we have a professional stenographer with us tonight. So it's all the more important that you enunciate your name clearly and give us your address, please.
My name is Jay, J-A-Y, Lee, L-E-E, 30 Hopeview Court, Newburgh, New York. Well, I want to thank you for allowing me to speak, and I stand before you today as a father of three, a resident of the town of Newburgh, and an ordained minister of the gospel of Jesus Christ. As a father, I'm responsible for raising my children to be responsible citizens. As a resident, I desire to see the town of Newburgh to be a safe place for all people. As a pastor, I am in charge of the spiritual welfare of our parishioners, where many of them live in this town. I want to clearly state tonight that I have no political or religious agenda. Many of us here are here to show support or oppose the pending moratorium. What makes our country great is that we could freely express our views. I believe what is important for us is not a short-term resolution, but a long-term resolution that will not only make my town, the town of Newburgh, a great place to live, but also a great place to do business for generations to come. We need a win for all. I wholeheartedly urge you to vote for the moratorium in order to make a sound decision in the near future. I'm not asking that certain types of businesses to not exist in the town of Newburgh. Businesses doing well in our town is good for all of us. At the same time, we want our town to be a safe place for all, whether you run a business or raise children. We need options for people to patronize businesses if they desire to do so, or to prevent young children from exposure to unsuitable settings. I understand that we're looking for a win for all. I believe that this moratorium will aid in making the town of Newburgh a better place for everyone. Thank you.
My name is Kimberly Paredes, K-A-R-I-T-I-S, and I live at 29 Hopeview Court.
Would you please speak up?
Better? Good evening. On my first visit back to this room since an elementary school tour, it was pointed out that the pictures were found in the Norman Rockwell fence in Rayton. I think that most of us long to have the pride in our town that is depicted in his prints. I was born and raised here in the town of Newburgh, and though I did live elsewhere for a few years, when the time came to buy a home and start a family, Jeff and I chose this town. When we first started our home search, we each wrote out our lists of what we loved about our childhoods and what we wanted for our family. I loved growing up here. I loved that I could hop on a train and be in the city. I loved that I had many, many trails to choose from if I wanted to hike. I loved that I could ride my bike around Meadow Hill. I loved that I could walk to my best friend's house without concern of safety and did it consistently for over 20 years. My wish for our daughter and any future children that we may have is that they have the same carefree, fun-filled childhood memories of bike riding, flashlight tag, backyard campouts, and the ability to walk to our neighbors' homes and feel safe. That is why I'm here tonight, to ask you to vote on this moratorium. Please take the time to zone our town properly so that all can prosper, and make our town the one that I remember from my childhood.
I can't be it.
How you doing? I'm Harry Decker, town resident for lifelong. The last time we were here, I had some concerns myself about what people were saying, the situation that they're in. So I listened to what they had to say. I listened to their concerns about their kids and the dangers and everything down there. So I took a few days off for work and I went down there and I sat for days and I watched and I drove around the neighborhood and I started picking out some of the dangers that I seen. And one, I'm not mentioning no names or nothing, but there was people in that development that concerned me to the point that I talked to some authorities about it. Because 65 miles an hour up a 30-mile-an-hour speed zone when there's kids from daycare walking on them roads in the afternoon is out of control. Another thing, we followed a bus one morning, picking up kids, little kids. 47 miles an hour we clocked this bus going through this development. That would concern me if I had a kid down there riding a bicycle or walking on a road more than some girls dancing in a club or having a steak dinner. The other concern was the daycare center up the road. I noticed a big danger right across the street. There's a place called AGL Welding. They handle oxygen acetylene tanks. And God forbid if it ever caught fire, because I've seen a building in Highland that stored acetylene tanks. The daycare center probably wouldn't be there afterwards. And if you go up the road another less than a quarter of a mile, there's a place called Weber Gas that stores major propane. If that caught fire and exploded, half the neighborhood down there wouldn't be there. Then I went down the road and there's a school, Bonneville School, which all I could find out so far, 2 cars has hit the front of the school. They put some barricades up, which deter them now a little bit. But that was a concern because the school was too close to a major highway. But less than a quarter of a mile from that, there's just been a new propane tank put in, which is a major concern. Because if that explodes, it's going to go that way too. And then I did a little more research. There is crime in the area. The development there is less than 2 miles from one of the major crime cities in our country. I mean, for the size of it and everything, it's worse than New York City. It's Newburgh. It's there. It's been there. We can't change that. So there is crime in the area. I mean, there was a young girl that was murdered in her beauty salon less than a half a mile down the road. There was a guy, a business owner, that was killed in his house less than a quarter of a mile on the other side of the hill. This place here has looked like a dump for years. You know, I've been driving by that place for 25, 30 years, and it really hasn't changed. The problem I have, this guy comes in, he's putting a lot of money in the place, he's trying to fix it up, he's trying to add more to it, he's trying to get a better clientele than what he has, to better the neighborhood, and to serve the public that is interested. If you don't want to go in there, you don't have to, like any other business in Newburgh. But the concern is, we put a moratorium on it. I don't know how much more the taxpayers in this town can withstand what it's going to cost us. So that's my personal feelings and all I have to say. Thank you.
businesses are identifying themselves by name and address. If you don't want to give your address, that's fine, I can respect that. Could you tell us what part of town you live in?
I live at 409 Quaker Street.
Thank you, sir. Thank you very much.
If I could, before the next commentator, I appreciate Mr. Decker's comments. I'm sure the board thanks you for your comments, but I do want to emphasize that Mr. Decker seemed to be speaking to very specific locations. And of course, the proposed moratorium would apply town-wide, is not directed at any specific use, business, site, or location in town. It is a town-wide proposal.
Jeff Caritis, 29 Hillview Court. I just wanted to thank the town. I think this is an issue that is, as stated, a town-wide issue. It's something that we probably should have done a few years ago, but it is where it is. As far as we're concerned, it has nothing to do with one place or another, as a town-wide situation, as you so noted just now. The negative secondary effects, as you review them and as you continue to go through them over the next 6 months, hopefully, will prove that there are things that happen to people's property values, to children, to women, to families. So what we're asking and what we're urging for the board to do is to vote on what is reasonable, a 6-month moratorium, so you have the time to properly do this, as you so noted earlier. And so I just wanted to applaud you for that work that you've done so far, and I look forward to seeing more good work come from you in protecting our town in the future. It's not about what has happened or what hasn't happened. It's about what can happen and the potential effects from whatever an adult-oriented business would be. We can't ban them, we understand that. They have to have places, and no one's even talking about that. But let's have places that make sense. And let's put them in places that are good for everyone in the town. So that way we can all live here and prosper, raise our families, and hopefully promote good business. I think it's great someone wants to invest in the community. We just have to decide what the best places for them to invest are. Thank you.
Good evening. My name's Gregory Barada. I'm not a resident of the town of Newburgh, but I live in the city of Poughkeepsie, and I also do plumbing. I'm a licensed plumber in the area, and I'm here. I am the manager of the current club that's there, and I will be managing the new establishment, which I hope we get to be built. But I do have a question, because you did say that it's not specifically targeted at anybody, and I just know that nobody spoke about zoning, any type of zoning for adult entertainment until this project was started. We've never heard anything about this. Nobody's ever mentioned it. That place has been there forever. And I feel like we are being singled out, because there's nothing wrong with the business. It's legitimate. If the zoning needs to be placed in place, that's fine. But I don't see how you can, we've been approved to do something. How can you try and minimize it now after we've already been approved and we've already started on the town's account? We were given permission to do things, and the ball's been rolling. And now to try and zone us, and I think that is singling us out. I really do. And I think it's not far-fetched for anybody else to grasp that. Thank you.
Chris Ty, 64 Western Drive, Newburgh. I'm not here to pass judgment on any of the adult establishments. I am curious what they might think of themselves as contributors to our welfare of our town. For example, there's one in my neighborhood that's 4/10 of a mile from the elementary school. I guess, at the time, the zoning was that they could do that. But again, I'm not here to ask them if they would, as the managers or owners, if they would build a house across the street and let their children play in front of it, especially looking like the one does on 17K. I'm not going to say it's an eyesore, but I'm wondering what redeeming qualities these establishments bring to the community. But they are allowed in. And you, the board, you're allowed to do certain things as well. And I know that there's been a lot of confusion over time regarding what can and can't happen in terms of, understanding among the residents. And it's kind of a complex issue. The research I've done tells me that there's a lot of case law that guides municipalities, and there's been a lot written about it. So I actually downloaded a document. It's basically about preventing the secondary effects of adult entertainment establishments. Is zoning the solution? So what I would like to do, if it's okay, is just give that to you for the record. Then anyone here can maybe foil it, or I can give them a link to it, and they can see for themselves just what you have to go through. I know it's not cut and dry. You can't just outlaw the establishments, obviously, and you can't just say, no, you can't operate, but there is a lot you can do. And a moratorium right now will, I think, help you discover what maybe some of those options are, if you haven't already. So I'd like to enter that into the record.
Let's give that to Mr. Zaretsky, he can enter that into the record.
Just to finish up real quick, just a quick little excerpt. The court also reaffirmed the city's ability to rely on evidence found in other cities about the negative effects adult entertainment has on the neighborhood. Because the court ultimately accepted the rationale that the city's goal was not to suppress expression, which is, they cite case law here, provided the most recent Supreme Court opinions, and the Seventh Circuit subsequently developed a test to synthesize the precedent. In other words, what they've done is they've given you different approaches. There's several prongs of approach that the town can look at. If an adult establishment is not considered obscene, is it then violating First and Fifth Amendment, that sort of thing? And they go through these series of tests. And ultimately, what that does is give you the framework and the guideline to move forward. Thank you.
Good evening. My name is Allison Lasardi. I don't live in the town of Newburgh. I live at 340 Dennytown Road, Putnam Valley, New York. My daughter, my son-in-law, my beautiful grandson live in the town of Newburgh. And so I'm here tonight in hopes that the board puts in the 6-month moratorium on adult-oriented businesses, permits, and approvals. This moratorium will give the town enough time to properly study and implement an adult-use zone per the town's master plan. Putting this moratorium in place is about protecting the entire town of Newburgh from potential negative secondary effects, which have been documented by numerous studies and research. As many of you know, or may not know, April is National Child Abuse Prevention Month. It's a time to recognize that we each can play a part in promoting the social and emotional well-being of children and families and communities. Our goal is to protect our children, families, friends, neighbors, property values, business owners, and everyone that is invested now and in the future of the town of Newburgh. We all win with this moratorium and the implementation of an adult-use zone, as it will make the town a better place to live and work. Please support the moratorium and protect the future of the town of Newburgh. Thank you.
Anyone else?
Good evening, Jessica Gardner. I don't live in the city of Newburgh, the town of Newburgh. I live in Port Jervis, New York. I'm a former reporter with the Times Herald Record. I got enlisted by Santa Monica Holdings to do a bit of research, and I thought it might be fun to share some of the things we discovered that may be helpful when you make your decision. By way of background, I've covered all forms of local government and state government, including a great deal of municipal government work that includes lawsuits that are often surrounding your decisions. One of the first things I discovered when looking into this particular issue was that a typical moratorium calls for a temporary halt to the consideration of proposals. It does not usually include those projects that have already earned their approvals and are awaiting a lawful building permit. Some examples include similar actions considered by Warwick, Wallkill, Bethel, Goshen, and Cornwall. Still, I want to step further and discuss the issue in general terms with the New York State Department. I asked John Wood of the New York Department of State's Division of Local Government Services whether moratoriums such as these typically include refusal to issue building permits. His answer was no. To quote, "Your client appears to have vested rights in the project and in good faith with approval in hand has been making improvements as requested and approved by the board. Generally, applications already in the pipeline and already this far in the process within approval are generally taken care of or exempt of a moratorium enacted at a later date. In fact, Mr. Wood referred me to the state-created manual regarding moratoriums, making specific reference to the first paragraph in the introduction. It reads, "A land use moratorium is a local enactment which temporarily suspends a landowner's right to obtain development approvals while the community considers and potentially adopts changes to its comprehensive plan and or its land use regulations to address new circumstances not addressed by its current laws." He highlighted the phrase, "obtain development approvals," and went on to say, "Since your client already has approval, how would the future moratorium apply?" I was a little puzzled by my request to begin with. Mr. Wood from the State Department went on to add, "Sounds to me this one's going to court unless the client gets a building permit before the moratorium gets voted on." He continued, "To avoid a legal challenge on what appears to be a hardship imposed on one applicant, I would imagine that the municipality might want to issue the building permit and then, only after then, pursue their moratorium to upgrade their laws." I'd like to make it clear that I understand firsthand what kind of political pressure each of you must be under regarding this particular project. But it is vital to remember that this is not a moral issue, but a legal one, with long-term financial ramifications to taxpayers if mishandled. We're all aware of similar zoning-related suits that have directly hit local taxpayers. Two examples include the recent landmaster suit in Montgomery, where taxpayers are being forced to cover over $500,000 in legal fees as a result of actions taken by town officials. Another stemmed from Westfall Township in Pike County, PA. That federal suit was directly related to the improper denial of a project and resulted in a $20 million judgment against the municipality. As a result, Westfall in 2009 filed for municipal bankruptcy protection, and the taxpayers faced increases of twice the legal limit for second-class townships without court order. We just ask that you consider these facts carefully before violating a property owner's rights to satisfy neighbors. A drawn-out legal battle won't serve anyone. And in the end, regardless of the outcome, you still have two existing gentlemen's clubs and a mountain of legal debt. Thank you.
Good evening, everyone. My name is John Capello, C-A-P-P-E-L-L-O. I'm an attorney with Jacobus and Gubitz. Live in Walden, but I have been representing Santa Monica Holdings and its proceedings before the Code Enforcement Department, the Planning Board, and this board for the past 18 months. I'm not really thrilled about being here tonight. I've worked and I've appeared in front of this board for over 20 years. This board has treated me with respect. Your consultants have treated me with respect, and I believe I've reciprocated. I've had success in this town, and I've had projects that did go through. All of the other times, the reasons were valid. I told my clients the reasons were valid, and I moved on. But this issue, what you're discussing tonight, is you're really treading on thin ice. I need to tell you, I presented you a package there with the facts, so I'm not going to come here and just issue empty threats. I provided you a mountain of evidence regarding the long procedures that this applicant has went through before your board. I understand Mr. Scully's discussion that this is a town-wide moratorium, but that ignores the history of what has been going on before your town for these last 18 months. you only have one establishment that has site plan approval to construct a legally valid expansion that has not been challenged. There's only one establishment, that's Santa Monica Holdings, that's on Route 9W, that's the elephant in the room. You cannot talk about a town-wide moratorium because it's going to affect nobody but this applicant. This applicant has not just a site plan approval, he's not at the beginning of the stage, he's at the end of the stage. He has the full building plans in before your board to construct his facility. He has all the approvals they need to construct this facility. They were given, and I'm going to go through the history in a second, and it's going to take a while, but they have went through every hoop, met with every department, met the concerns of each and every one of your consultants, both at the planning board and at the town level, posted money, posted letters of credits that this board approved and hold to begin that construction. Now, this discussion you're having would have been a great discussion to have a few years ago, and I probably wouldn't have had anything to say. If we didn't have an application in and we didn't have an approval, that study you're doing would be absolutely valid. And you could study secondary effects, but you have to understand individuals have land use rights as well. This individual has been through the process and has rights. You cannot ignore these rights. Now, your municipality has had zoning since 1974. You've acknowledged in your comprehensive plan that since 1974 to this minute, which is almost 20 to 8, on April 2nd, 2012, you have not regulated adult-oriented businesses. That's not at the behest of my client. That was at a decision of the Town of Newburgh Board. You could not prohibit those uses, so it's clear that they were allowed to proceed in the Town of Newburgh. And all those years, with no regulations at all, you still only have 2 establishments. Despite the map that shows Gold's Gym as an establishment, there's only 2 establishments within the town over that course since 1974. Since there were no regulations, this facility on 9W was operating as a restaurant. Sometime around 1990, it converted to provide adult entertainment. There are several correspondence that are all in the package I gave you in Exhibit A, where your building department has acknowledged that the use of the facility was a lounge/adult establishment, or in other words, an eating and drinking establishment, which is the only definition the establishment would come over. It obtained variance from your ZBA to cut off a portion of the lot to divide and devote to another business, whereas if it was a non-conforming use, it wouldn't have been allowed to subdivide. The ZBA allowed it to subdivide. My clients purchased the facility in 2009. At that time, they went to the board to pursue renovating, improving, and upgrading the facade. So when Mr. Todd talks about what are my clients doing to upgrade the facility, they're trying to build a new modern building that includes a full-service restaurant to replace the old dilapidated building. So they're doing exactly what was requested of them. They went before your board. There was some concern. Their prior consultants went before the board and said we're not conforming use. The ZBA said there's nothing in the record that you're not conforming. We're not granting you the right to extend the non-conforming use. They came to my office, we looked at the code, and we said, well, you were established after zoning was adopted, so you couldn't have been a pre-existing non-conforming use. So what are you? Here are all these letters defining you as an eating and drinking establishment. We submitted a letter to your code compliance officer, who is the person who made those decisions, set forth the facts, discussed the prior ZBA approvals back in 2005, all of which is in your package, discussed the fact that adult uses weren't regulated, discussed the historic use of this facility as an adult use, and were provided on August 5th, 2010, a letter from the code enforcement officer to your planning board, not to us, saying that this facility, the existing facility, fit within the definition of eating and drinking establishment. Therefore, it was permitted. In Based on that letter, we went back to the planning board. We appeared at 3 public meetings at the planning board. At the August 5th meeting, the planning board was told by Mr. Canfield, and it's included in the notes of your planning board attorney who was at the meeting, that the use could proceed. The purpose of Mr. Canfield being at those planning board meetings is to advise the board when an application needs a variance, when it's permitted, and whether it complies with the code. He was present at those meetings. He raised no objections to that use. We received conceptual approval on August 5th, 2010. In December 2010, we went back because we had a long list of comments from your planning consultant, from your traffic consultant, from your landscaping consultant, from your engineers about significant improvements they wanted done to the site. We addressed those comments, went back to the board in December of 2010. At that meeting, we discussed the floor plan for the proposed new use in detail that showed substantially the layout that is proposed now. You have the minutes from those meetings in the package I provided you. You have the comments from Code Compliance Officer Canfield, once again raising no objection to the use. The planning board continued to review it, scheduled a public hearing. In January of 2011, they held the public hearing. The notices was prepared by the planning board's consultant, not the applicant. It was sent out to those property owners as directed by the planning board. That public hearing was held. It advised the neighbors of that a site plan was being considered. It advised of the location of the property. It complied with all the regulations and was similar to the site plan notices prepared by your planning board for several public hearings. I also let you know that your code does not require a public hearing for site plan. It is optional, nor does the state law require a public hearing for a site plan. But your planning board determined to hold a public hearing. They held a public hearing, and in that meeting, they adopted a negative declaration. They adopted the negative declaration in December. They adopted a planning board site plan approval. The resolution was prepared by your planning board attorney. It was filed in the town clerk's office as required by law in January 24th of 2011, well over a year ago. The law provides that anyone who has a problem or is aggrieved by an action of the planning board in granting site plan approval has 30 days to challenge that approval. It's now April 2012. That approval hasn't challenged. That approval is valid. Based upon that approval, the applicant came to this board, and this board approved a bond amount and letter of credit in the amount of $138,000 that the applicant was required to submit to this board. That was submitted. It's held by the board in the amount of $138,000 to ensure compliance with the erosion control plan, to ensure compliance with the significant over $40,000 worth of landscaping to be provided, and the installation of sidewalks. This board also authorized the supervisor to sign an agreement whereby my client committed that he would maintain the sidewalks that he was required to construct along Route 9W in the state's right of way. That agreement has been signed. It was filed. It was signed both by my client and by the town supervisor. During that time, the planning board, the code compliance department, and this board had full knowledge of the plans and how that building was going to be used. At no time was there any discussion or concern regarding that discussion. Now, you hear a lot about the comprehensive plan and the comprehensive plan recommending a study. Nobody's mentioned that comprehensive plan was adopted in October 2005. And it said the committee discussed the preparation of a plan and said the town should, not must, consider a plan and, if deemed necessary, adopt regulations. You didn't do it in 2006. You didn't do it in 2007. You didn't do it in 2008. You didn't do it in 2009 when my clients purchased the property. You didn't do it in 2010, the year my client had an application before your boards to consider. And you didn't do it in 2011 after you accepted a bond, accepted money, and held money for construction to occur as in compliance with this site plan. Those are rights my client holds. If in 2007, as I said, you did this study, adopted a law, and said you can't be 1,000 places from a daycare center, even if the daycare center is established after the adult use was established, my client would have come to me and I would have said, you know, there's nothing you could do, continue to operate as you are. You're not prohibited, but you didn't do that. Once again, it wasn't at the urging of my client. It wasn't because of pressure. You determined not to do it. Now, at this 11th hour, to consider it, my client has expended, after he got the site plan, after he posted all the ponds that were required, he submitted a building permit application, and at that time, asked the code compliance department, well, I have a site plan approval, I have an erosion control plan, can I commence site filling and commence work on the site plan? And he was given that authority. He's spent over $450,000 in reliance upon those approvals. When you have approvals, and those approvals go unchallenged, and you have the authorization of the board, and then you undertake and you expend money based upon those approvals, you then have rights. I understand the concerns of this neighborhood, and I wish they would have been there during the process because they could see that the facility that is proposed will be a much nicer, cleaner, better facility. It will have state-of-the-art erosion and control, state-of-the-art stormwater drainage, the driveway will be improved, it will offer full food service, it will still offer entertainment, that's the facility, but it's a brand new, modern, attractive building with over $40,000 of landscaping, stones, architectural features at the entrance of the facilities, sidewalks in compliance with the requirement of the DOT in conjunction with quick checks. All that was done in reliance upon approvals, not just by one board, by the planning board, by the code compliance department, and by your board. Now to say, well, we had a study, we had a suggestion in 2005 that said we should do secondary uses, and we haven't actually issued the building permit before, and I'm not going to go in. I gave you chapter and verse about all the requests we made for building, the building permit, about the correspondence back and forth, changing requirements about a ZBA appeal that was made, about stays that really couldn't be enforced, but that was still, I don't want to use the word manipulated. I'm not here to confront now, I'm here to provide the facts. But the fact is, I believe my client was entitled to that building permit, and that last piece of paper seems to be held up now as a reason to say, we're going to put the genie back in the bottle, start the whole process, the $450,000 you spent, ignore that. The hundreds of thousands of dollars you paid our planning board consultants to review this, and your consultants and engineers and planners and landscape architects to prepare that. Forget about all that. That all disappears. We want to start from scratch. Unfortunately, you can't do that. Okay? You just cannot do that. And that's why I'm not here to make threats. I'm here to tell you, my client has no choice now. It's not like before he broke ground, you said, you know what? There's some places, other places in the town that we would like you to go to, and if you go there and you find property there, God bless you, you can build, and everybody would be happy. That would have been great. That didn't happen, and it's not my client's fault that it didn't happen. Okay, he followed the law as you wrote it. He asked before he did anything. He responded and replied to every comment your board had. I wish you would go talk to the planning board to ask them. Nobody hid anything during that proceedings. Keith Slipstein, my client, and his people responded to each and every request of that board to make this a first-class facility. I understand people don't like the use, but since 1974, this town chose not to regulate that use. They can't do it now. Now, as to the moratorium and the standards for the moratoriums, and Jessica did a great job, but the purpose of a moratorium is to stop a rush of development and to be adopted when there's a dire necessity. Now, there have been concerns raised, but there's been no evidence of any dire necessity, nor have there been any evidence of secondary effects other than reliance upon studies from Times Square which although you can consider studies from other municipalities, they have to be relevant to your municipality. Someone else another attorney is going to speak on that issue much more, but we did a quick review and we did some requests to your police department to ask what are the actual secondary effects related to this establishment on 9W, the one that's entitled to a building permit. And we found out that over the last 7 years, there were 122 calls over 7 years related to the facility on 9W. 6 of those resulted in police reports or arrests. I listed the types of arrests that they were. Now, contrast that with the convenience store gas station at 17K at Cumberland Farms. Over that same period, had 321 calls and over 21 arrests. So, in the town of Newburgh, a convenience store that sells beer or sells alcohol or it's open late actually could result in more crimes and has resulted in more crimes than the adult use establishment in the town of Newburgh. Yet, adjacent to this facility is a Quick Checks that was just approved and is under construction, just like this facility is under construction. Now, armed with that information, are you going to adopt a moratorium to stop the Quick Checks and say we got to check the secondary use study because there may well be as much crime associated with that facility as there is from the adult establishment? I don't think you will, because I think you know. Quick Checks will have ratables and there'll be other positives. Quick Checks is a great, by the way. I'm not here to demean Quick Checks. They're a great facility. They're run well. But the fact is, based upon your records in the town of Newburgh, not in the city of Austin, Texas, not in Times Square, but in the city of Newburgh, the facility that exists has not generated crime. The facility that's run by the applicant who is going to run the new facility has not generated crime. So there's no proof or no evidence before you that this will generate any more crime in this area than currently occurs. Additionally, there's talk about reduction of property value. But I saw in the paper, and I was looking at one of the people who were objecting, complaining that they spent $500,000 for their home recently, which they bought, by the way, for $500,000 while the adult use establishment existed on the facility. Have you checked in to see, has there been any evidence that the homes in this area, because of this adult use establishment, are valued any lower than homes throughout the rest of the town? I don't think you'll find evidence. We have the developer who developed the project right up the road there. They sold just as well, and they sold for just as good a price during the good market as any other home in Newburgh, and they probably tanked just like the rest of the Hudson Valley has in the last few years. Hopefully they'll rise again, but there's been absolutely not one shred of evidence provided to you during this whole time of discussion about this facility since December that this project has any negative impact whatsoever on home values. Yet at the time, literally at the 11th hour and 59th minute, you're seeking to pull the plug on that's entitled to a building permit. I have a lot more facts throughout here, and I could go on a lot longer. And, I just want you to understand that we've made every offer. We've met every requirement. I've given you a mountain of evidence to consider here, but adopting this moratorium will cost my client his livelihood, their livelihood. It will cost them significant amounts that they've expended in reliance upon the approval, and they will have no choice but to seek legal redress. Jessica mentioned Landmaster. I can think back to standing before the Town of Montgomery Board the night they adopted their exclusionary zoning, having the same type of speech to them. They looked at me, they said, thanks very much, we're going to take our chances. And it's $750,000 that they paid, and attorney's fees aren't covered by your insurance. The taxpayers, had to pay that, so you need to consider that. You cannot let someone go down the line that far and then say, we are going to pull the plug without considering the impacts that will have. that, I'll conclude my presentation unless you have any comments, but I really think you should rethink this action. There are actions you could provide. You could adopt a law right now that says no adult use establishments within 1,000 feet of any existing establishments. You can include the buffer that say no new establishments within 1,000 feet of any residential district. All those laws will probably go unchallenged and say the facility that has existed, that is seeking to improve, we will allow to approve to the extent that we approved it, and you will likely have no challenge. And you can monitor the facility, as Mr. Pasquadio said in response to an email that one of the residents raised. He said, as with all commercial uses, we will continue to observe and make sure that they comply with all the regulations of the site plan. I would expect you to do that. I would expect you to hold the applicant to a high standard. As Supervisor Booth said on numerous television clips what I saw in December when this issue was first raised, and the newspaper reports, the applicant went through the procedure, complied with the law. He's entitled to proceed. We will look going forward to see what we can do to address these issues. You had every right to do so, but you do not have a right to go back to someone who has been through the process and say we're pulling the plug. Look at your code. Look at your provisions when you adopted residential lot area changes. You exempted in 1992 any applicant who had preliminary or final approval or site plans that had completed the environmental review process. In 2011, while this application was before the board, in 2011, when you adopted the new lot area requirements, you included a grandfathering clause in your code then that says any application that has final approval, site plan or subdivision, not issuance of a building permit, is exempt for these regulations. So you do have a history of understanding the importance of land use rights, the importance of the process from your planning board, and acknowledging those rights when you adopt the law. I would ask you to do the same for my client. Thank you.
Before the next commentator, I'd just like to point out, given the reference to pulling the plug that was made several times, and the previous speaker as well, it should be noted that the proposed moratorium does not identify any use or business and applies to each adult business within the town and any adult business that seeks to locate in the town, because it is, as the supervisor has mentioned, and I have mentioned, a town-wide moratorium.
Yes, hi, my name is Mitchell Colker. I live at 14 Hopeview Court in Newburgh. And, I'm a little confused. I came here tonight expecting for us to talk about a moratorium, not to single out any one specific business, but to talk about a moratorium for the town of Newburgh to zone adult-oriented businesses properly. I'm a professional here in the town of Newburgh. I take care of a lot of kids. I'm a physician. These kids, are important for our future. They reside in Newburgh, and they're going to continue to, hopefully, stay in Newburgh. This is, we are affected, but we are not singling out one specific business. Any of us in the town of Newburgh now are vulnerable to have a strip club or whatever adult-oriented business open up on our corner with no regulation right now. And what we're asking for is regulation in order to zone, to give us a moratorium to study the effects. I know they presented a lot of things, but that's the whole point of the moratorium, to give us 6 months so we can all sit and examine the secondary effects, the plus, the minus, locally, nationally, what have you. But that's what it is. It's not to make any decision more than to study the facts. And that's what myself as a resident, I expect to live here at least another 20 years. I love living here and I love participating in the community, and really this whole thing has made me excited, because what I'm seeing is that we are looking to make the town a better place for not only ourselves, selfishly, but for our children and their children. Thank you very much.
Supervisor, members of the council, my name is Luke Lareau. My address is 22
2240 Bel Air Road, Suite 190, and that's in Clearwater, Florida. And I'm here as a guest of Mr. Capello. I am a First Amendment specialist. I have represented political candidates. I've represented priests who were told they had to take crosses out of their yard. I've represented law enforcement officers. I've represented demonstrators. And as you can probably guess, I've represented a number of adult entertainment establishments over the last 25 years. The last time I had the privilege to come up here, I had two cases, one in Wappingers Falls and one in Hyde Park for adult business there. And I guess I was lucky we prevailed on both those cases, neither of which were in the precarious position that you find yourselves in based on the factual scenario that's been described to you by Mr. Capello. Let me tell you a few things. I am a past president of the First Amendment Lawyers Association. I actually had the privilege of giving the annual report on the regulation of adult businesses. So there isn't a case out there anywhere in the country that I haven't read. There isn't a study that's been cited that I haven't reviewed. And many of those reported decisions, certainly nationwide, belong to me. So I think I have a little bit of the background to tell you a few things that perhaps you may not be aware of. If you are, forgive me. Perhaps it's an important issue for your community. But I just want to explain one thing. The First Amendment, to the extent that it protects my client and the message that he hopes to convey, also protects all of the other speakers that have made their points to you tonight. And I wouldn't have it any other way. The only difference is that when you took your office, you put your hand on the Bible, I believe, and took an oath to uphold the Constitution, not the other way around. And that's the important theme that I'd like to emphasize for this presentation. If you look at the whole concept of the secondary effects that you've articulated as what you want to study, they really didn't exist until 1976 when the Supreme Court decided the first case that ever dealt with that issue. And these are important because if you understand the history, I think it will give you a better idea of where you are and how you got here. That case was Young versus American Mini Theaters, and actually it was a case where the city of Detroit, rather than regulate adult businesses, was trying to protect downtown Detroit by adopting what they referred to as their anti-skid row ordinance. And it precluded the prospective development of pawn shops, blood banks, temporary help agencies, and adult bookstores. The important thing that I'd like you to know is that it was prospective only. It didn't affect anyone that had been in operation or that had filed an application for operation. And it's been that way throughout all of the First Amendment jurisprudence that's emanated from the Supreme Court since the 70s. Some of the earlier speakers talked to you about being able to rely on other studies. The actual case that created that concept was called the Renton versus the theaters there, Renton versus Playtime Theaters. And in that case, the Supreme Court said that you can rely on foreign studies as long as you believe those to be relevant to the problem that you're addressing. A lot of the cases that have come out since then have criticized sharply small, rural, or less developed communities relying on the studies that were created by bigger communities. And candidly, I've probably taken the depositions of most of the authors of those studies. Most of those studies were created after the fact by communities that were trying to protect previously adopted adult entertainment legislation. And what they did is they would gerrymander the evidence. One of my favorites is Indianapolis. Out of the 60 businesses that they studied, they chose 6. And I think the quote in the study is that they did it for manageability reasons. Well, if you actually look at the data which is attached to the study, if you do a Freedom of Information request, you'll find that they chose the worst 6 because the others could not be shown to create these adverse secondary effects. And again, the difference here is all ideological. People don't want their community to be a bad community, but if you really look at the evidence, you'll find that the Upscale Gentlemen's Club, which is what certainly these folks are proposing to open and operate, is not the location of adverse secondary effects. It may be the location of a controversial form of expression, and it might be the location of expression that some people find objectionable, but that doesn't give people who don't like those businesses a superior constitutional position to interfere with a plan that has been in process now for quite some time. When I was first asked to look into this issue, I articulated the issue as one where, has there ever been a case decided where the development approval process, once begun, was ever found constitutionally withdrawn after a community decided to adopt an adult entertainment regulation. And a moratorium is pretty much the same thing, because the way the courts look at it is that if you're in the process of trying to express yourself and participate in your rights of free speech, which I'm sure your counsel are aware are manifest in these types of businesses, whether it be a civil rights parade, the publication of a newspaper, the presentation of a speech, anytime that the government stops you from doing what you've planned to do, that's called a prior restraint. And I think the case law is pretty clear. A prior restraint comes before the court with a heavy burden of unconstitutionality. In this instance, what I would suggest that you do to prevent the unconstitutional manifestations of your goals, as I find articulated in your proposed moratorium, is you need to exempt out anyone with an active development review process ongoing. Then you can do what you wish. That moratorium will not be a restraint. Then it will give you the chance to study those particular research issues that you've talked about. And candidly, I think what you'll find, and I've brought a number of studies with me tonight, I'll be happy to share those with your counsel. The studies that I have produced and have had the access to over the last 25 years are basically expensive to promote and very expensive to undertake. And candidly, what they show are these things: that there is no adverse impact on property values caused by an adult entertainment business, which is the subject of a dramatic investment, such as the facility that our client is hoping to present here. There's no proof that it increases crime. Obviously, the issues of crime are such that if you look at the actual calls for service for these different establishments that Mr. Capella talked to you about, that really is your experience. And what I will say is that in the most recent Supreme Court decision, the Alameda Books decision, it says that you can look to foreign studies, but you can't do so at the expense of ignoring your local historical experience. So for instance, if you want to look at the Times Square study, which I will certainly submit does not show that adult businesses cause an increase in crime, you can't do that at the expense of ignoring your local history. Now, if you had no adult business here, it would be different. But since you have had adult businesses in this area, they have created a certain list of characteristics that can be studied. The beauty of the studies that are produced and basically undertaken to explore these issues are that they're all based on the statistics. Property values, maintained by the government. Calls for police service, that's maintained by the government. The businesses that have conducted these studies don't do it independently. They rely on what the government has produced. And candidly, like any other case, when you get into court, they dust off the scales, you put your evidence on, and if our local evidence shows that there is not the problem that you articulated, that this general moratorium undertaking is designed to address, then candidly you may have a shot. But I would certainly advise you to take a good hard look at the Freedom of Information materials that our client has put together. One of the things that I think was an issue that I always address, and I've probably been to well over 100 similar hearings, there's a concern about the children. Well, we wanted to test that theory, and candidly, if you do a research project with the Library of Congress, if you want to look at situations where children have been abused or been victimized by other human beings, you will not find one story reported anywhere in this country over the last 20 years where a child was victimized by the patron of an adult entertainment establishment. That's not how it happens. The people that abuse children are people that put themselves in careers where they have access to children. And the patron of an adult dance club is not going to be the person that will victimize someone else's child. I understand the concern that there's no evidence to support that connection. The other concern that I've responded to are, well, our child will drive by this location and they'll feel that there's some sort of problem with this objectionable business. And in speaking with child psychologists, as I have, to explore this issue, what they'll tell you is that, for the most part, children of a certain age will never notice the business. It doesn't look any different than the plumber or the baker, the donut shop or the car repair shop. It's just another sign on the highway. But when they do notice it, that's an indication to the parent that they are becoming more sexually aware, as all human beings become at a certain point. And that's basically the tip-off that a responsible parent will have to explain those situations to his child. So there really isn't any downside to that, and I don't think that the signage at this particular location is going to be offensive by any stretch. It's certainly not going to have any graphic anatomical areas exposed or defined or articulated. So I can tell you that in any jurisdiction that I practice in, representing
hundreds, if not thousands of adult businesses. I don't know a single jurisdiction that wouldn't jump up and down to have the opportunity to improve what's there now with what's being proposed. And quite honestly, it surprises me that at this point, with all of the development approvals having been given to this point in time, for you to say that this is just a general moratorium that's designed not to affect this client, but to affect everybody and it's townwide, I just don't think that there's any district court judge in the country that would buy that. And I hope we don't have to take the opportunity to find that out. You are acting in a way that is depriving this gentleman and his partner of known constitutional rights. And what I don't think your clients and your counsel have told you is that that exposes you to individual liability. You no longer hide behind your official capacities. When you act knowingly to deprive someone of known constitutional rights, you get named as individual defendants just like the town, just like the Zoning Board of Appeals. I think you should be aware of that because quite honestly, there's no doubt in my mind that what you're doing, and if you look it up, it's called a Bill of Attainder, that under the guise of legislation, you're really affecting tangibly the rights of only one party. I think if you peel away the layers of the onion and take a good hard look at what you're doing, I think if you want to do the right thing for your community, for the Constitution, and for yourselves, you need to exempt this client out and grandfather him in at this point, having gone through all of those development review processes with approvals that he relied on to expend the amount of money that he's expended. I'm happy to answer any questions that you may have. And again, I'm not here to threaten you, I'm here to educate you, and I hope I've done that. But quite honestly, this isn't an issue that our client created. He came to you in good faith, never hid for 1 second the proposal that he had in mind. And quite honestly, at this point, it's too late to take away the vested rights that he's acquired without serious sanctions. Thank you.
I'm Erin Weck. I live on Orchard Heights Drive in Newburgh. I grew up in the Hudson Valley. I didn't grow up in the town of Newburgh, but my husband and I did choose to live here, to move here. We've been here almost 4 years, and I've said many times, and I may be repetitive, but I love the town. I've made incredible friends with my neighbors. I've had such a great experience. I certainly want to stay here, probably for the rest of our lives. We are in love with the town and in love with our neighborhood. I'm just here to support the proposed moratorium on adult use businesses. I believe in change. Maybe I'm an eternal optimist, but I believe in positive change, and I believe in it for the town of Newburgh. And I just really, I really hope that you guys support this moratorium as well, because I think it will be an incredible change for our town and protect everyone in the town of Newburgh. So I hope, that's all I want to say. Thank you.
Thank you.
Hi, Chris Ty again, 64 Western Drive, Newburgh. I just wanted to come up again for a moment, only because I heard my name mentioned earlier. And I want to clarify that in case I was misunderstood. In regards to these sorts of places, I believe that there's two kinds of seed. There is the appearance of the place, for one. You can guess what the other may be. But when it comes to the town, trying to decide what your town's going to look like. You've been working on a master plan and completed, I believe, for the last, 8 years or more. So this town has been actively engaged in shaping what development's going to look like going forward. This is nothing new. And we've been through the discussion of moratorium over the years many times. Would we allow a sewage treatment plant on 9W just because the person who owns the land, and maybe they're going to do some sort of private thing, wants to put it there? And maybe residents come late to the party because they work every day, they do their thing every day, they show up, all of a sudden, what's this? And then they get into a setting like this and they're told, well, where have you been? We've been working on this for a year. As if they simply haven't been paying attention or been asleep. I kind of resent that part a little bit. But I want to point out too, that there seems to be a indication that this is zeroing in on one particular applicant, and obviously that's not the case. And the town has good standing as far as the New York State Department of State is concerned. I was referring to James Kuhn's local government technical series, where he writes, where a more restrictive ordinance, and actually this is case law, is enacted, the owner will be permitted to complete the structure or development and it has been rendered non-conforming only when the owner has undertaken substantial construction and made the expenditures prior to the effective date of the moratorium. They refer to a case, Pete Drown versus Town Board of the Town of Ellenburg. In that particular case, it was upheld by the appellate court. That particular applicant spent about $850,000 and was still denied. The reason being is, we all know that in the state of New York, you don't have vested rights until you have a building permit, approval, and have spent a substantial amount on construction. I don't think they're there yet, but that is for the attorneys to decide. A constitutional attorney, wow, from Florida. That's impressive. You know, you guys, you've faced down some attorneys before in the past. We have a long history of being threatened in this town. And, well, you know, you pretty much made it your goal to, whether you did what's right or not, to try to at least do what's right. But common sense, people. A child's not affected by an adult seedy entertainment place anywhere. When the child says, Daddy, what is that? And you're cringing, and you're like, all right, I guess we have to have that conversation. Maybe he's right, I don't know. But I think common sense dictates that you're not going to be fooled. I personally am not against development. I actually love development. I love ratables. I just like also to keep my property values, and I like nice development. I like to see a good place. And I'm not just talking about pretty windows or whatever. There's plenty of places in a town where adult establishments can be, where they can function, maybe whether they're grouped together, maybe they're dispersed, but where they are also in the appropriate place. Personally, I think 4/10 of a mile from an elementary school is a bit much, but there it is. Thank you.
Good evening. My name is Michael O'Brien. I live on Pressler Road, Walking, New York, Town of Newburgh. I originally started at Blue Moon in 1991, and I sold the property for Santa Monica Holdings. I'd like to make it known that it almost seems that there's going to be a lawsuit one way or the other here. If he doesn't get the new building built, he's still going to have the existing building, the existing use. The people are still going to have a strip bar in their neighborhood. I do have a proposal. I haven't run it by anyone. The developer that built those houses came to me and wanted to buy my property. And we were unable to negotiate a figure at that time. But he thought of the same thing. I do own a strip of property behind it, and what they could do is they could connect Cherry Lane into DeVito, close DeVito off. You wouldn't have anybody's cars going up there. I heard some of the concerns of the residents. There's something that some of these people could think about. Because either way, there's a strip bar there, whether it's larger or smaller. And, you know, it might help some of their needs. But I didn't really come here to sell real estate. I came here to talk about secondary effects. But I will pass it to the board to take a look at. They talk about adult-oriented business having secondary effects. I was in business here almost 20 years, and I feel there's a lot of other businesses that have much worse secondary effects than the adult entertainment business. Most recently, Route 32, a restaurant having a sweet 16-year-old party, had 2 shootings, the windows broke out. Nightclub on 17K, hotel, gunfire, 100 people fighting. Back in 2004, 2006, drive-by shooting, a restaurant over on Route 300, 2 times. 2008, pizzeria on 9W, busted for a pound of cocaine, 5 pounds of marijuana, reopened the following day. Big box retailers have the police there constantly. I think we're getting a bad rap, and we always got the bad rap as the adult industry. The town really has to look at what's in its town, and not these studies from other places. I'm sure I can't say it better than the First Amendment attorney could say it, but that is the truth. But then going further into this, if you look at your proposed zone, 1,000 feet from any residence, I feel it's too restrictive. That wipes out the entire B zone. There's only 2 spots left in the B zone that could possibly have adult entertainment. And I'd like to ask the town, do they have any indication of how many adult businesses are in the town presently?
We're just here to hear the comments, we're not gonna get into a...
Oh, no. Okay, no answers, okay. Then in the proposed moratorium, they would like to put adult businesses in the IB and the I zone. Well, the IB zone is consistent of many industrial parks. And under 185-41 business parks, the purpose of establishing them was not to have conflicting or incompatible uses. So you're trying to now put us in a zone where it's zoned not to have us. The zone is not large enough to accommodate the adult businesses we presently have, so therefore it needs to be worked on. Now everybody talks about the school. Well, it's unfortunate that the school's in the business zone and it's not a permitted use in the business zone. How that happened, I don't know. And if you do adult zoning, I'd like to see it protected where churches and schools could not move into the adult zone. Because that's what happens in the city of Newburgh. They had an adult zone, they allowed a church to move in the middle of it, and then it wiped out the adult zone. So, I could go on a lot more, but I think you've heard it. Thank you.
My name is John Friedel, 1 Midway Drive. I support the moratorium. I understand that the attorneys are, and maybe rightfully so, I don't know, are making an issue over the current construction. From my understanding, which I'm totally baffled on this entire thing, is it was turned down by the zoning board. How can your zoning officer overturn what the zoning board says? So therefore, if it's not technically supposed to even be happening, without affecting anybody, if we want the moratorium. People know that I've lived by this for a long time, and I've had the house for a long time, and I've had issues. I'm not saying I had shootings in the yard and such, but I've had issues. There's no alcohol there now,
throw alcohol in the mix, I'm gonna have a lot more issues, you know? And, we're not talking 1,000 yards from my house, we're talking the other side of the street. I can underhand throw a rock into it, you know what I mean? It's not even a big deal. And you don't need to go through Cherry Lane, just stick it back in 9W where it belongs. Don't put it into a residential neighborhood, and any business shouldn't be allowed in a residential neighborhood. And I'm picking you guys a little bit. Your whole thing about the way you send notices, you know, I got the public notice, like, for the zoning board thing, 4 days before the thing. You know, this is ridiculous. You don't give a guy time to do anything, you know, and they're talking about public notice before. I never got it. Somebody signed a card. It wasn't me, and it wasn't my wife, and it was printed. So I don't know how this ever happened, why this ever went through. I never got notice of this at all, you know, and I never got a chance to go to this planning board thing, which should have been if your zoning board turned it down, and I never got a chance to do anything about it, you know, and since obviously your zoning's in a bit of disarray and nobody knows exactly what's going on, I really think you need to have a moratorium and figure out what's going on here and how you want to proceed in the future, and then we won't have these issues. Thank you.
Hi, I'm Bob Diamond, I live on Hopeview Court as well. I just want to bring up a couple of points. Number one, we've heard many situations where there's lack of notice to this project. We heard at the zoning board of appeals at the last meeting as well, that there were people who showed up who lived within 300 feet of the property, who had no notice at all whatsoever. So there's one reason right there that you guys need to do a better job figuring out really what's going on here. Because there have been people who have not been given notice. Second, regarding the issue about secondary effect, when you're bringing up, you know, looking at the strip joint that's there now, typically on any Friday night, there's what, 4 cars in front of the place? 4 cars. Now we're talking about 190 to 200 people being in that place and selling alcohol. So we're kidding ourselves that there's not going to be a secondary effect here. This is not going to be the same thing that we had for years, you know, with the institutions there today. It is going to be totally different. It is going to be vastly worse than it ever was because you have alcohol, and once you throw alcohol, it's like throwing a match on gasoline. And then you put up 200 people in that building. It's going to get a lot worse. And as these folks have rights, so do we. We have spent a lot of time in that neighborhood. We spent a lot of money on taxes. We are good residents, and we're just looking for what's fair. And I think I applaud you guys for actually entertaining this tonight. I really do, and I thank you very much. Keep in mind one other thing. 9W is one of the entrance points to the town of Newburgh. And as you're coming through Middle Hope, that's the first town you hit when you're into Orange County. And the first thing you're going to see on the left-hand side is the mansion, which is going to say one thing. Wow, what kind of community really is this? That's going to be the front door of your community, one of the front doors of your community, just so you know that. Thank you.
Hi, I'm Joe LaRoja at 2Apr12 Court. There are a lot of statistics here tonight, but I think the quality of the statistics have to be looked at. While there might be more kids at a quick check running out with a six-pack or something, I don't think anyone here is concerned with that. I think the impact of one crime on one of our children that will cause them trauma the rest of their life is worth 10 quick check burglaries and a six-pack of beer on a Friday night. I also hear 450,000 bantered around, but I guess I asked the board to look at the value of one child's life. Thank you.
Anyone else?
I'm Harry Decker again. I keep hearing about the child's life. So far, I haven't heard any evidence that a strip club has hurt any child. But if you look at the news and read the papers, when they go to school, you got to be really concerned. When they go to church, you got to be concerned. When they play sports, you really have to be concerned. Because right now, there's numerous people that's been arrested and are on charges that's in our schools, in our churches, and in our communities that affect kids. And I have 5 kids, I've raised 8, and I'm concerned about the kids too. But, you know, there has been nobody brought any evidence that the strip club has hurt any child in the past, ever. Thank you.
Hi, I'm Nicole O'Connor, OCANA, and I live on North Hilly. I have 3 small children, a 2.5-year-old, and I just had twins 1 month ago. And I cannot imagine them having to ride their bike in 5 years from now and have to see an adult use business. And everyone's talking about all the other crimes that go on in Newburgh. Why do we want to add to that? That's what the moratorium is going to do. We're going to study those and see what the secondary effects are. So I really appreciate you taking the time to look into this, and I hope that morally you make the right decision. I'm sure a lot of you have children and grandchildren, and you would not want an adult use business in their backyard. Thank you.
My name is Art Armento from New Windsor. I go to some of these other clubs. There's no children that can go in there. There's no indicator on the door that it is a strip club. Kids can go online and see much worse than they could get by walking by one of these clubs, okay? The people that work there, I know a number of them, I'm friends with Keith. A lot of them are single moms, okay? They are working to support their kids like any woman would do, and they don't have a big education, and they're not on welfare, okay? They're not going to be able to support their kids working at Burger King, Walmart, places like that. So basically, they're not a burden. Keith is not doing anything here that's going to be detrimental to the kids, okay? There's more. I was raised a Catholic, okay? I went to Catholic schools. There's more problems with priests messing around with kids than there ever would be in places like this. That's the rest of my kids.
Christopher Bisler, 17 Corbin Hill Road. Just like to address that I've lived in a quarter mile of the strip club that's currently near my house since I've grown up. I'm not for or against the businesses. It did not affect the way I was raised in any way, shape, or form. I did ask what it was about. I was told that it was an adult business and that would be discussed when I got older. I think that's what all kids should be told. I never had a problem driving my bike by it. I went to school near it. Didn't ever affect the way I was raised. Again, I'm not, for or against the business. There's a business out there to make money. That's what they're there to do. Depending on the business, yes, there's restrictions that should be put in place. Unfortunately, after you invest so much money into a business to go forth with a project, I don't think that should be overturned. Again, I know that you're not saying that that's just for this project in general, but for the town overall. Any money invested, you should consider that. But in the future, you should consider making this change for other businesses that may want to come in the future. Thank you.
Hi, Mitchell Colker again. I just want to say, obviously, First Amendment rights, everyone has a right to speak. Everyone has good ideas, and a lot of them are anecdotal, not backed by any real, research or evidence, just their own feeling, like, I rode by the strip joint, I'm fine. Well, that's one individual case. The point of a moratorium is to study this. That's the whole point of it. We can give anecdotal cases that I drove around the community, that I rode my bike by the strip joint, that I never knew what it was, but when I did, I said, oh, that's we're not talking about one individual strip joint. These places, saying they're not negative to the community, our man from Florida, they're not negative, right? But are they good for the community? I mean, is it like, oh, I want to live by a strip joint? When we moved in, there was a little tiny strip joint, no one ever went there, and now all of a sudden, a huge one's going up. You have to ask yourself, at this point in time, a huge one can go up anywhere in the town of Newburgh, and that is the point of this, to instill a moratorium, to properly study the effects, and not looked at individual anecdotal cases on why it's okay to have a strip joint. Thank you very much.
Anyone else?
My name is Paul Marston. I live at 6 Court in Newburgh. There's quite a number of people here in the room that have not gotten up to speak tonight, and so I just want to say something short and sweet. I would support the moratorium. I think there's been a lot of discussion here, and it is worthy of further study. And I think that's the right thing to do, and I would ask you to do that. Thank you.
Hi, my name is Harry Hutzianakis. I live on Hopeview Court, and I have 2 small kids. And I actually disagree that no, the kids will not read any signs. They actually are very curious. They start reading at the age of 5. My daughter's 9, and you know, she's already started asking. I don't think it's 9 years old. I don't think it's it's an appropriate age to go in detail as far as with big, you know, signs going up 10 feet by 11 right off of the road where they could read it right from their bus. I think they should be a little bit older before you actually start talking to them about more in detail about businesses like that and what people do and why. We live only a 3-minute walk from the establishment, and if we're 3 minutes from there, someone that is actually a customer is also a 3-minute walk up the hill to our neighborhood. So there's no force field. You don't know what type of people go there. I do not believe that basically all the people that attend these adult nightclubs are your everyday, you know, normal, you know, citizen that doesn't commit crimes. And I am for the moratorium. Please try to, you know, do the research and we can come to some type of answer for this issue that we have for our neighborhood. It is going to be a billboard to the entrance to the town, and we have what daycare center, you know, within probably a 1/10 or 2/10 of a mile from the establishment, in addition to the elementary school. And there's a lot of new families that are moving into the neighborhood, a lot of kids, and it's just it's wrong that they would have an entrance from a residential area to enter this establishment. Not to mention a huge sign that they plan on putting. This is going to be 6 times the size of the current establishment, and this is why we're here. It's not a renovation, it's a major construction of a new building, and that's what we're here for, because I think it's not going to be good for the town in the long run. Thank you.
Hi, my name is Tim Fisher. I live at 49 Sloan Road with my wife and 3.5-year-old daughter, and I'm here to simply voice my support for the moratorium on adult use businesses in the town. Thank you.
Good evening to everybody, especially the board. My name is Carol Slow, and I reside in the Orchard Heights development, which is one of the developments affected by the new establishment. And I urge this board, and I do support the moratorium. Thank you.
talk about their children. They probably don't realize that the movie theater comes under the adult entertainment. So they have no problem taking their child to see a kiddie movie here and an R movie in the next wall over. But again, it's a lot bigger than just one outlet, and it's going to affect a lot of businesses in the town. As it stands now, it's a job killer. It's a small business killer. As far as property values, I went to open up the drive-in theater years ago, and I couldn't get approvals through the planning board. It sat vacant for almost 20 years. They wanted us to put in a traffic light. It's not the reason why the property value went down, the building sat there. It's a small business can't afford to put in traffic lights to open up with that type of business. And I don't think property values got hurt one bit by an adult establishment being there. Barnes & Noble falls under an adult establishment. I don't think it hurt the property values over on that side of the town either. These are things that the board needs to consider.
Hi, I'm Mary McEnroe, 1573 Route 300. I'm sitting here listening. I'm not really an advocate of adult entertainment. I don't go there, but I do know some people that do. I know some people that work there. And I was listening at everybody getting up saying how old they are. Well, I've been out here for 20-something years. I raised my children out here. They're adults. I have grandchildren. They're well-adjusted. You can have more damage done to them by them going to church. You give your children to the adults, the priest, the pastor, the teachers, and you have no question about who you're giving them into the hands of. So they get damaged in school, at church, on the street, in their homes. You have a lot of fathers and mothers that are molesting your own children. So you say, what do you tell your children? You teach them the truth. That's what I did. We rode past the place. It was a little establishment over there. My children asked what it was. I told them what it was. You speak the truth to your children. You teach them. You have, someone said that they don't know who go in there. Well, you have business people that go in there. And they enjoy themselves, I guess. So what I say to you is, those of you that are new in the area, you teach your children the truth. You tell them what it is. I have a granddaughter that was reading at the age of 3. We go past somewhere, she would say the letters, and then she would say what it was. So I can't lie to my children. I refuse to lie to them. I refuse to lie to my grandchildren. For instance, the Disney movies. The palace, the top of the palace, was the shape of a penis. What did you tell your children? Did you pay attention to it? Did you look at it? When Simba flopped down on the grass, the letters came up sex. Did you tell your children that? Did you explain that to it? No, some of you sat there and you enjoyed the movie and you did not pay attention to what was in the movies. So what you tell your children, you tell them the truth.
Anyone else?
Hi, I'm Snaracini. My last name is spelled S-E-N-E-Y. I live on Hopeview Court. I moved here about 5 years ago to the town of Newburgh, and in that short time, so much has developed here. It's really a wonderful place to live. All of 317 didn't exist when I was here, pretty much. And I think the purpose of the moratorium is to find out what's going to happen in the future and to protect us from things that could be potential threats to our communities. So I think we're going a little over and thinking that we're singling out a specific person. I think we just want to make the community better and understand how to do that. Thank you.
Anyone else? Any board members? Questions, comments? I know we have a lot to digest. We've been giving several several volumes. But I'd like to do this in a timely fashion. At the end of the meeting, I'm going to ask to have this recess, if it's equitable, to Wednesday, and to make a decision on this, whether we enact or don't enact the moratorium. So at the end of the town board meeting, I'm going to ask to recess this. I know evenings are, Wednesday evening is difficult for a couple of individuals, so I'm going to ask her to, we'll recess it to the Wednesday afternoon, 3 o'clock if that's, all right. Okay.
Is the meeting room free? And Mr. Zaretsky's waving at
Oh, we'll make it free.
Oh, okay.
It's always through Deborah. I'm just questioning your procedure. I don't think.
As of right now, I'm going to ask for a motion to close the public hearing. I was just making that as an announcement.
So move yours with request.
And I'll second.
Motion made and seconded to close the public hearing. That motion was made and seconded at 8:48 p.m. Mr. Piaquadio seconded it. Mrs. Green made the motion, Mr. Piaquadio seconded it. You're welcome. Mr. Woolsey? Yes. Mr. Piaquadio?
Yes.
Mrs. Green?
Yes.
Mr. Bello? Mr. Booth?
Yes, thank you, everyone.
Thank you.